Before the sentencing hearing even begins, you can already sense that this case carries a lot more history than what we're about to hear in the courtroom. The defendant standing here today is Leif Burleson, a 50-year-old man facing sentencing after pleading guilty to an assault charge. Now, normally, sentencing hearings are the final step in a case. The evidence has already been presented, guilt has already been determined, and the judge must decide the consequences. But what makes this situation more complicated is the background the defense is about to reveal. According to the attorney, Burleson has recently lost his mother, lost his home, and has been living out of his car while trying to rebuild his life. On the surface, that sounds like someone who has hit rock bottom and is asking for another chance. However, judges don't only look at recent hardship. They look at patterns of behavior over time, and the judge in this courtroom has already reviewed a detailed pre-sentence investigation report. That report includes the defendant's criminal history, substance use issues, and interactions with the justice system over many years. So the real question hanging over this courtroom today is simple. Is this a man who deserves another opportunity, or someone who has already used up too many chances? Let's see how the judge responds.
This is case number 25CR42644, the State of Ohio versus Leif Burleson. Mr. Burleson is before the court with his counsel, Mr. Borger. Ms. Tranter is here on behalf of the State of Ohio. We're here for sentencing. There was a pre-sentence investigation prepared. Everyone's had an opportunity to review that?
Yes, Your Honor.
All right, Ms. Tranter, anything on behalf of the state?
Nothing further, Your Honor.
Anything from probation?
Nothing further, Your Honor.
Mr. Borger?
Your Honor, I know that we had some discussion back in chambers, but I want to reiterate a couple things. One, I've been able to read the pre-sentence investigation, also been able to read the letter that my client had sent to you. I'm frankly surprised at the letter that he had sent to you. I don't know that, well, I think that he wants to discuss that, but essentially what I want you to know is that he's had a very tough time of it very recently. His mother died. He was living in his mother's home over in Hamilton. That home got sold, and when it got sold, he had to live out of his car hotel. It's no excuse for what occurred. He took responsibility for the assault. I think that the letter he sent to you may have obviated that somewhat, but I don't think that that's what his intention was, at least in my conversation with him. He understands that there are consequences here. I will tell you that he has a couple things on the horizon that will be beneficial to him. He's got a sister in the local area that he can live with. He's a contractor, so he's skilled in that he can get some work and he can maintain that work. He's also talked about, and his sister from North Dakota has been in contact with me about moving to North Dakota to get a fresh start period. I think that will be the best thing for him. We ask that you take that into consideration.
The defense attorney is doing exactly what experienced lawyers often do during sentencing, building a narrative of hardship and recovery. He emphasizes that the defendant recently lost his mother, lost his housing, and has been living in unstable conditions. By mentioning family members willing to help and potential work opportunities as a contractor, the defense is trying to show the judge that Mr. Burleson has a support system and a possible path forward. In many sentencing hearings, those kinds of arguments can actually influence the outcome. Judges sometimes choose probation instead of jail when they believe the defendant has the resources and motivation to rebuild their life. But here's the important part. Judges don't base decisions purely on sympathy. They also weigh criminal history, behavior during the case, and whether the defendant accepts responsibility. And as this hearing continues, the judge is about to bring up details that suggest this story may be far more complicated than it first appears.
Mr. Burleson, anything you want to say?
Well, first, I'm sorry about the letter. I was angry. I admit that. Not at you, more at myself and the situation. I lost everything, Judge, all the way down to the picture of my daughter, who's no longer with me, I'll never see again, and I literally can't see her face. That bothers me tremendously. I mean, it eats me up. I said in that letter, Judge, I'm 50 years old. I've made a lot of foolish mistakes. In your courtroom 5-6 years ago, I said the same thing. I was wrong then. I'm wrong now. I should have never been in that position with this woman. I should have never been arguing with somebody at 11 o'clock at night. That's on me. I am guilty of that. Absolutely. And, you know, what else can I say other than I got 8 weeks till winter kicks in. I can't work. I'm trying to get my life together. I still owe him court costs. I lost everything. I'm not asking you to think, I'm not saying justified. I'm not shunning responsibility. I'm guilty. And I'm sorry to her, you, Ms. Tranter, court. myself, it's been a rough road. And I can only ask you now, I've been in here 76 days, 3 months on house arrest, which I know doesn't count. But I made an effort. I paid hundreds of dollars. I had to peddle my mother's things just to do that, to come to court, Uber fees and stuff. You know what I mean? I don't want you to have sympathy on me for that. I'm not justifying it. My dog, my cat, everything's gone. And, you know, another day in here, I hope that that's not necessary. Please let me go. I still got to go to Hamilton County and deal with the misdemeanor there. You know, my sister's 1,000 miles away trying to help me. Please just let me.
That statement from the defendant is clearly an attempt to show remorse and vulnerability. He admits that he made mistakes and repeatedly tells the judge that he's trying to take responsibility. At the same time, he describes losing everything: his home, his belongings, even personal memories like photos of his daughter. Moments like this can be powerful in a courtroom. Judges often want to see genuine acknowledgement of wrongdoing because it suggests the person understands the consequences of their actions and might be less likely to repeat them. However, sentencing hearings are rarely decided on emotion alone. Behind the scenes, the judge has already reviewed the defendant's entire criminal record and behavioral history. If that history shows a consistent pattern of offenses or poor decisions, even a heartfelt apology may not be enough to change the court's decision. And very soon, the judge is about to address exactly that: the defendant's past.
Out of here.
At some point, Mr. Bertelsen, I don't understand, just in reviewing your record, I mean, this is, you have some pretty serious cases that you picked up down in Florida.
Yes, sir.
Burglaries, attempted burglaries, robbery. I mean, this is not your first go round. You've been before this court before. You have a substance use disorder that you seem to just kind of gloss over. In fact, the recommendation is that you do an inpatient treatment program, and I will tell you that it's fairly rare for the assessor to recommend that. I'm just telling you that right now. Even in this case, you tested positive for methamphetamines, and at 50 years old, it's time for you to stop using illegal drugs, recreationally or otherwise. It's time for you to start obeying the law, and this whole attitude that you have that the law doesn't apply to you. You tried to manipulate this case. You tried to manipulate the witness in this case, and you can deny it all you want, but
now we're starting to see why the judge seems skeptical. When reviewing Mr. Bertelsen's criminal history, the court points out several serious offenses from the past, including burglaries, attempted burglaries, and robbery charges. Those aren't minor mistakes. They're significant crimes that indicate a long relationship with the criminal justice system. On top of that, the judge highlights another serious concern: substance abuse. According to the pre-sentence investigation report, the defendant tested positive for methamphetamines during this case. That's a major red flag for courts, because drug use is often linked to repeated criminal behavior. But the most troubling accusation the judge raises isn't just about drugs or past crimes. It's the claim that the defendant tried to manipulate or pressure a witness to drop charges. If the court believes that happened, it shows a willingness to interfere with the justice process itself. And that accusation is about to make this hearing even more intense.
the evidence was very clear that you tried to coerce her into dropping these charges. I'm actually quite surprised that the prosecutor didn't try to charge you with an additional felony for that, but they didn't. It's hard. It's very hard, and I understand you're in a bad situation. But the problem that I have is you put yourself in this situation. Your choices through your life, the last 30 years, have put you in this position. So it's very hard to have sympathy on you when it's your choice. It wasn't my choice to put you in this situation. It was yours. When you make bad choices, there are always bad consequences. Whether they're immediate or not, there's always bad consequences, and you continue to demonstrate that you make bad choices. So I don't know what you want me to do about that. But I understand you don't want to be on supervision, so the only option left for me then is to not offer you any assistance, but simply to try to punish you in this case. Because the purposes and the principles of sentencing, which I take into consideration, one of the things is the seriousness of this. The victim in this case is dead through no fault of yours. Did you have something else you want to say?
Dead? The victim's dead?
I'm sorry.
I didn't know that.
I misspoke.
I'm sorry.
I misspoke.
Judge, I do want to say this. The last time I was in supervision, you gave
I'm thinking of Miss Hyatt's case.
I was going to say, you're confusing your cases, I
did.
think,
I
Judge.
did. I
Yeah.
retract that. I'm
Right.
thinking of a different case.
I'm sorry. It's not, you could put me on probation, Judge. I don't have a problem with that. I never said that. If I did, I didn't mean to. I was on the probation and did quite well. I successfully completed it. In your courtroom, I had 3 years, and I got off in a year. I paid my fines. I work. When I work, I do well. You know, and you're right. I have a substance abuse problem. I do, Judge. I was clean for a long time. No excuse. Listen, I'm sorry. I'm not shunning responsibility. I'm not trying to manipulate you or anything. I said in that letter, if I'm guilty of anything, it's being in that position in the first place that I put myself in. I'm not blaming this on anybody. It's been 6 years since I've been in trouble, and I'm just asking you to let me out to go to work, to rebuild. I'm not shunning that responsibility, Judge. I'm guilty.
When asked about the case, you said, if there was a victim in the case, Mr. Bertelsen answered, yes, me, I'm a victim.
I'm sorry.
Mr. Bertelsen, is there anything else that you want to tell me? Because get it out now, because once you're done and it's my turn to speak, I don't appreciate being interrupted. Again, this is just part of your whole attitude, and I'm going to get to it here in a second, your whole attitude towards authority, your whole attitude towards the system. It's just, you need to change it, because you're always going to end up in this situation. And again, you do not garner much sympathy from the court when you continue to act this way. So is there something else you want to say?
No.
All right. When asked if there was a victim in the offense, Mr. Bertelsen answered, yes, me, I'm a victim. She obstructed, she perjured, she is free. I lost everything. She fed me months of arrest. I'll not apologize for it. This whole system is full of shenanigans and is disgusting. I literally lost everything, and she feeds me, and I'm in more trouble. This is all a joke. Everyone should be ashamed of themselves. This isn't justice. So how do I reconcile that with your coming in here saying, oh yes, I've admitted my guilt, I was wrong? How do I reconcile that with what your words are? This is after you've already pled guilty. And then you send a letter to me, which I read, by the way, and indicate that.
This moment is incredibly damaging for the defendant. The judge reads part of a letter Mr. Bertelsen previously sent to the court, and in that letter, his tone is very different from the apology we heard earlier. Instead of taking responsibility, the letter suggests that the system itself is corrupt, and that the defendant views himself as the real victim in the case. Statements like that create a major credibility problem when the same person later stands in court claiming remorse. Judges pay close attention to consistency. If a defendant says one thing in writing and something completely different during sentencing, it can appear as though the apology is being made simply to reduce punishment. You can hear the frustration building in the judge's voice as he asks a very direct question. How can the court reconcile those two completely different attitudes? At this point, the judge has heard everything he needs to hear, and the final decision is about to be delivered.
You admitted your guilt, but you kind of said in your letter that you didn't do anything. How do I justify that?
I was angry, Judge. I lost everything. I was just angry. There was a video. I did walk away. I did get punched, spit in my face, slapped, hit, my property destroyed. That did happen. It doesn't justify nothing. But it did happen. I was angry, Judge. And I can tell you, I'm sorry.
I'm going to go further because you couldn't stop there. During the process of preparing this report, that they had some follow-up questions for you, and your response was, fuck probation, I'm not speaking to them. Then you called back and you answered the questions. This is for pretrial. asked if you'd be willing to comply with all orders of the court if granted community control. Your response was, I will not do community control unless it is non-reporting. I have given enough for this M1. I want to rebuild my life. I'm going to resolve the M1 Hamilton County, then go to North Dakota. Right?
I didn't write ever anything about F probation or whatever that was. I don't know what that's about. I mean, again, I'm no position to sit here and say, hey, it's just a misdemeanor. Judge, all I'm saying is, I'm not going to say anything because I'm obviously getting myself in more trouble here. Look, I'm sorry. I'll leave it at that. I was angry.
And now we arrive at the moment that determines the outcome of this entire hearing. After reviewing the statements, the pre-sentence investigation report, and the defendant's long criminal history, the judge makes a decision that may surprise some viewers. Instead of placing Mr. Burleson on probation or supervision, the judge orders 136 days in the Warren County Jail, giving credit for the 76 days he has already served. What's particularly interesting is the judge's reasoning. He says he's not going to place the defendant on supervision because Mr. Burleson repeatedly indicated he didn't want or value that kind of oversight. In other words, the court believes additional programs or monitoring would likely be ineffective. Cases like this raise an important debate about the justice system. Should courts prioritize rehabilitation and treatment, especially when substance abuse is involved, or is it more appropriate to focus on accountability and punishment, especially when someone has a long history with the law? Now we want to hear your thoughts. Do you think the judge made the right call in this case, or should the defendant have been given probation and treatment instead? If you enjoy watching real courtroom breakdowns like this, make sure to like this video, share your opinion in the comments, and subscribe to the channel for more intense courtroom moments and legal analysis.
All right, the court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Burleson, I'm not going to supervise you. I'm not going to waste everybody's time. You clearly don't want help. I don't think that putting you at this point in time in an inpatient treatment facility that you're going to like that or that you're going to want that. So I'm just going to order you to serve 136 days in the Warren County Jail. You'll get credit for the 76 days you've already served, and then you will be terminated. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. That's it. Anything else?
No, Your Honor.
All right, that's all.